Hey, parents, I want to go over the Texas Rules of Civil Procedure. And I really just want to go over Rule 7. But before we start with Rule 7, I think you guys need to know a little bit about the Texas Rules of Civil Procedure. So, a lot of us are in family court. And if you've been following me, I've been telling you guys that I have been filing my criminal complaints into my family civil court case. And a lot of people have told me you can't do that, Mr. Saldana. We don't handle criminal complaints. We're a family district court, and so I want to address that issue. And there's something else that I found last night, and I think it's of importance, and I wanted to share it with you. If you go to the bottom of Rule 1, you'll see these rules shall be given a liberal construction. Well, we all know what construction is. We see it all the time in the cities that we live in. So the way they're supposed to build these rules shall be liberally. And if you're a pro se litigant, you know that your motions and your pleadings all should be construed liberally. Okay. So if we keep scrolling to Rule 2, you'll see that it says these rules shall govern the procedure in a justice, county, or district courts of the state of Texas. So these rules only apply to a justice court, a county court, and a district court in the state of Texas. Now, let's get to rule number 7. So if we scroll down to rule number 7, it says may appear by attorney. May appear by attorney. Any part to a suit may appear and prosecute or defend his rights therein, either in person or by an attorney of the court. Okay, let me reread that. Any party to a suit may appear and prosecute or defend his rights therein, either in person or by an attorney of the court. That's your basic constitutional right to represent yourself. So in our field, interference with child custody or perjury or aggravated perjury, some of those big issues that we have in these family courts that they're not admonishing, they're not doing anything about, they just simply tell you, hey, Mr. Saldana, there's nothing we can do. Well, to me, it looks like it's wrong. Again, this isn't legal advice. This is just me reading and comprehending. So what does the word prosecute mean? So let's go to prosecute. So we go to Cornell Law School, and we just want to talk about the word prosecute. In criminal law, prosecute means to initiate criminal proceedings against a person. In criminal law, prosecute means to initiate criminal proceedings against a person. So that's why I've been filing my criminal complaints into my civil family court case, because law enforcement and the district attorney's office won't allow me to make my criminal complaints of perjury, aggravated perjury, or interference with child custody. So that's going to take us where? To the Code of Criminal Procedure. If you go to the Code of Criminal Procedure, Chapter 2.05, look it up. Code of Criminal Procedure 2.05. When a complaint is made, if the offense be a felony, he shall forthwith file the complaint with a magistrate of the county. Now, if it's a felony, it shall be forthwith. Now, perjury is not a felony. Aggravated perjury is a third-degree felony, and interference with child custody, a retention in violation of your court order or judgment, is a state jail felony. So all of these felony complaints, when law enforcement deny you, they're actually denying you your First Amendment right to bring your criminal complaint before a magistrate of the county. Forthwith, meaning immediately. Now, your criminal complaint does have to abide by the state statute on how to write a criminal complaint. You can find those in Chapter 15 and Chapter 45 of the Code of Criminal Procedure. Now, magistrate of the county. Let's go to that one. What is a magistrate of the county? Who's a magistrate? Well, a lot of people don't know that, and I've been telling people that district court judges are magistrates. So if you scroll down to 2.09, who are magistrates? It'll start right here. The justices of the Supreme Court, that's a civil court. The justices of the Criminal Appeals, that's criminal court. The justices of the Court of Appeals, which again is another civil court, and the judges of the district court. Now, they do have other stipulations in which you can go through and you can look for. My cases in Harris County. And so my family court judge, and you can look up your court in the government code, and you can look up, like mine is the 309th court. You can look it up and it'll tell you which cases that court gives preference to. Some of those courts might give preferences to criminal um, cases. Some may give preferences to family cases, and some of them just don't give any preferences. Now, preferences mean preferred. It doesn't say exclusive or only. So again, who are magistrates? The justices of the Supreme Court, justices of the Court of Appeals, or criminal appeals, and the Court of Appeals, and the judges of the district court. Now, remember, guys, again, this isn't legal advice. I'm not trying to tell you how to do things. But when law enforcement doesn't allow you to make a criminal complaint in violation of a court order or judgment, and you have Texas Penal Code 2503, interference with child custody, a state jail felony, law enforcement won't take it, the DA won't take it. You have to remember that your family court case, that judge, if you're a district court judge, has exclusive jurisdiction over the order in which you are making that criminal complaint. So this is just one tip. If you go back again to Rule 7, any party to a suit may appear and prosecute or defend his rights. A lot of us are respondents. A lot of us are the ones they come after, right? We're on the defensive. We're defending our rights. But I want parents to start thinking about this word, prosecute. And I want you to think about it and tell me what you think in the comments below.